if I told you that the very first piece of free standard paperwork you sign to register your brand new business is also the exact document that's most likely to, destroy it during a boardroom dispute?
Oh, it is the ultimate legal trap for new founders. I
Yeah.
mean, you think you're just checking a compliance box, but you are actually planting a time bomb right in your foundation.
Yeah, that's terrifying. So welcome to this deep dive. Today, we are taking a really hard look at the absolute foundations of your business.
Right.
And our focus today is squarely on you, the listener. So the founder, the solopreneur, the visionary who is currently operating without employees,
Yeah.
but really wants to expand and grow.
Exactly.
Because the core objective here is to build a rock-solid legal structure so you can actually scale up without being completely crushed by the weight of, compliance.
Yeah, and we're drawing on a highly comprehensive toolkit today. It's called Legal for Startups, and it includes presentation slides, video transcripts, and legal workbooks that span across 5 modules.
It's massive.
It really is. The goal is to help you navigate what often feels like this intimidating legal maze, right? But to do it quickly, systematically, and reliably.
Okay, let's unpack this. Because before you can chase that growth or attract any funding, you got to build that foundation.
You do.
Getting the basics right starts with your structural setup. And according to the toolkit, your very first major legal decision is choosing your entity. And they strongly advocate for registering a private company rather than just operating as a sole proprietor.
They do, yeah. And the reasoning really comes down to 2 things: risk mitigation and market perception.
Right.
So a private company creates a distinct protective legal barrier, right, between your personal assets and your business liabilities.
So if things go south, your house is safe.
Exactly. If a client sues the business, your personal savings are generally shielded. But beyond that, it's about market trust. I mean, funders, investors, even large corporate clients, they just inherently trust the structured, regulated nature of a private company way more than an individual operating alone.
Which brings us back to that time bomb we mentioned at the very start.
Yes.
When you register a private company, the CIPC, which is the Companies and Intellectual Property Commission, they automatically give you a standard default document called an MOI, or Memorandum of Incorporation.
Yeah.
And our sources describe this as basically your company's constitution.
That's right. It dictates how the business is structured, how major decisions are made. But, and this is key, the sources stress that relying on that standard CIPC document is incredibly dangerous.
Okay, I really want to understand the mechanics of that risk. Because if a government body literally issues you this standard MOI for free during registration, how can using it be a bad thing for a brand new solopreneur?
Well, it's because the standard MOI is practically hollow.
Hollow.
Yeah, instead of spelling out the specific rules for how your unique company should operate, it relies heavily on these default clauses, and it just constantly references various sections of the National Companies Act. So if you want to know the rule for removing a director or issuing new shares, the document essentially just points you to a massive, complex piece of legislation.
Okay, so if we compare this to building a house, it's like getting an architectural blueprint. But instead of showing you where the load-bearing walls go, the blueprint just says, refer to page 400 of the National Building Code.
That is a brilliant way to look at it. Yeah, you end up constantly flipping back and forth between your MOI and these dense legal statutes just to understand how to run a simple board meeting.
That sounds like a nightmare.
It is completely user-unfriendly. And when rules are vague or hard to access, disputes inevitably arise. So the toolkit insists on drafting a customized MOI because it removes that ambiguity. It puts all your specific operational rules right in plain sight.
That paints a very clear picture. So you customize the MOI. Now, alongside that, there are other crucial registrations to get out of the way.
Right.
I know the toolkit mentions income tax with SARS, the South African Revenue Service, which they say is usually automatic when you register with the CIPC.
Yes, usually.
And there's also the CSD, the Central Supplier Database, which you need if you ever want to pitch for government contracts.
Very important.
But the one that really stood out to me was the Department of Labor registration for workman's compensation. Sometimes they call it the ROE, or return on earnings.
Oh, yeah. That one catches a lot of people off guard.
It definitely surprised me.
Yeah.
Because the sources make a very specific point that you need this registration the exact moment you hire even one part-time person.
Yeah.
But wait, if it's just me, And like a single part-time virtual assistant helping out 5 hours a week, is a formal labor registration really necessary?
It is absolutely non-negotiable. I mean, founders often assume that things like workman's compensation are only for, heavy manufacturing plants or companies with massive payrolls.
Right, like factories and stuff.
Exactly. But the legal mechanism doesn't care about your size. If that part-time assistant develops carpal tunnel syndrome from typing for you, or they trip over a cord in your office, that registration is literally the only thing protecting both you and them financially.
Wow. Okay, so the physical house is legally built. We have the private company, the custom MOI, the SARS, and labor registrations. Now we need to figure out who actually holds the keys before anyone else moves in.
Right.
And that brings us to internal alignment, shareholders, and directors.
This is an area where early-stage founders often hesitate. They just assume they're too small to need formal internal paperwork.
Which was exactly my reaction when I read about the shareholders agreement.
Mhm.
Because the toolkit says this agreement dictates what happens during worst-case scenarios.
Yeah, all the bad stuff.
Right. Like if someone wants to leave, if the company suddenly needs funding, who takes surety for loans, or what happens if a partner becomes insolvent, is convicted of a crime, or gets severely ill.
Heavy topics.
Super heavy. And if I'm sitting alone at my kitchen table running this business, drafting a legal document about my own potential death or bankruptcy feels a bit morbid. It feels like a distraction from actually finding customers.
I get that. But if we connect this to the bigger picture, you'll see why it's not a distraction. It is a core strategy for growth.
Okay, how so?
Well, you might be a solo founder today, but the objective of this toolkit is to make you capable of scaling. So eventually, you may bring on a co-founder or an equity investor. And if you wait until you have a partner to try and negotiate what happens when things go wrong, emotions will already be involved.
Ah, right. You don't want to be negotiating the terms of a divorce while the house is actively on fire.
Precisely. Let's look at a hypothetical. Say you bring on a 50-50 partner, and 2 years later, they unexpectedly go personally bankrupt.
Oh, wow. Okay.
If you don't have a shareholders agreement detailing a legal mechanism to value and transfer their shares, those shares might get tied up in their insolvency proceedings.
Yikes.
Yeah, your business could freeze entirely. You wouldn't be able to vote on major decisions or attract new investment. Drafting this agreement up front provides a pre-agreed escape hatch.
Okay, viewing it as a legal escape hatch makes a lot of sense. So that covers the owners, the shareholders. But then there are the directors, the people who actually run the day-to-day operations.
Right, the boots on the ground.
Exactly. The sources detail the need for a director service level agreement and a board policy, really emphasizing that directors have incredibly strict statutory duties.
Yes, they do. Directors have a fiduciary duty to the company. The law requires them to act in good faith, in the best interests of the company, and with a proper degree of care, skill, and diligence.
Right. But let's translate that into founder reality. What does breaching a fiduciary duty actually look like for a small startup?
Well, a classic example is a director using company assets for personal profit.
Like what?
So if you are a director and you take the proprietary client list you helped build for the startup and you use it to launch your own side hustle, that is a direct breach of fiduciary duty.
Wow, okay. And the toolkit also highlights conflicts of interest as a big deal.
Oh, it is a massive compliance trap. So if a director has a personal financial interest in a matter being discussed by the board, say the company needs a new software vendor, and the director's sibling owns the vendor company being considered, they absolutely must formally disclose that interest.
What actually happens if they don't disclose it? Does someone just get like a slap on the wrist?
Far worse. Failing to disclose a conflict of interest can legally invalidate the board's decision entirely.
Wait, entirely?
Yes. That contract you just signed with the vendor could be deemed void. The only way to rectify it is through a really cumbersome formal shareholder resolution or even a court order. It just paralyzes operations.
Dealing with all these structural documents, policies, and agreements, it sounds overwhelming for a small team.
It can be.
But the toolkit has a really interesting approach to this. They suggest borrowing tools from the world of project management to handle your legal setup.
They do, yeah. Specifically mentioning the fishbone diagram and the RCI framework.
Now, I'm familiar with a fishbone diagram for root cause analysis, using it to figure out why a legal gap exists rather than just treating the symptom.
Right.
But how does RCI apply to drafting legal documents? Like, what does that actually look like in practice?
Well, RACI is an acronym. It stands for Responsible, Accountable, Consulted, and Informed.
Okay.
And by applying this to your legal compliance, you break a mountain of paperwork into delegated tasks.
So it's about assigning roles.
Exactly. The responsible person is the one physically drafting or reviewing the MOI. The accountable person is the founder whose neck is on the line if the document is flawed.
Right.
The consulted party might be an external legal advisor you talk to before finalizing, and the informed parties are just your team members who need an update when the new policy is active.
So it basically stops the legal setup from being this vague cloud of anxiety and turns it into a concrete checklist. That's incredibly practical.
It really is. It creates total clarity on who is doing what, just ensuring nothing falls through the cracks.
So the internal rules are set. The foundation is poured. Now it's time to actually grow the business.
Yes, the fun part.
But as the sources point out, sustainable growth is about improving the customer experience and expanding capacity, not just inflating your payroll with permanent employees.
Which brings us to a major theme of the toolkit, right? Insourcing versus outsourcing.
Yeah.
For a solopreneur, utilizing external resources is the safest way to scale before making the heavy, highly regulated commitment of formal employment.
I honestly love this model. It reminds me of how modern Hollywood movies are made.
Oh, how so?
Well, you don't keep an entire army of actors, stunt coordinators, and lighting techs on a permanent studio salary all year round, right? You hire specialized independent professionals for the exact scenes you need them for. When the project is done, the contract ends. It keeps you agile.
That is exactly the dynamic the toolkit recommends. But to do that safely, you need to understand the different legal vehicles for collaboration. The sources outline several types. You've got independent contractors, suppliers, joint ventures, agencies, distribution, and referral partners.
Okay, let's actually walk through these because the lines seem a little blurry to me. What is the practical legal difference between hiring an independent contractor and signing on a supplier?
What's fascinating here is how the exact nature of the value being delivered dictates the legal relationship. So an independent contractor provides bespoke, specialized services.
Like a freelancer.
Yeah. For example, if you are an app developer and you hire a freelance graphic designer to create the UI for your new project, they are executing a unique service.
Got it.
That contract needs to focus heavily on intellectual property ownership, making sure you, the founder, actually own the final designs.
Okay, and a supplier.
A supplier delivers specific goods or highly standardized services. Think of a company that supplies your office internet or delivers packaging materials.
Okay.
A supplier agreement isn't usually worried about intellectual property. It focuses on delivery timelines, physical warranties on the goods, and payment terms.
That makes total sense. Now, what about a joint venture versus an agency? Because those sound much heavier.
They are definitely heavier. A joint venture is when two independent businesses decide to collaborate on a specific project, sharing both the risks and the profits.
Okay.
So if your tech startup partners with an established marketing firm to co-launch a new product, that's a joint venture. The contract has to clearly define how revenue is split and what happens if the project fails.
And an agency relationship.
An agency relationship carries a completely different risk profile because an agent can legally bind your brand.
Oh, wow.
Yeah, think of a real estate agent who has the authority to sign a lease on behalf of a property owner. If you grant someone agency to act on behalf of your startup, their signature becomes your obligation.
That sounds terrifying if you don't have the right boundaries in place.
It can be.
And the sources also mention distribution and referral partners.
Yes. A distributor buys your product in bulk and resells it, taking on the inventory risk themselves. A referral partner simply points leads in your direction in exchange for a commission without ever touching the product.
Okay, so clearly, understanding the exact relationship is step one. But the toolkit says that for any of these contracts to actually hold up in court, they have to meet 4 non-negotiable requirements.
Right.
Consensus, capacity, a lawful objective, and proper formalities. I think consensus, like a true meeting of the minds and a lawful objective, make obvious sense. You can't write a contract to do something illegal.
Exactly.
But how do you actually prove capacity, and what do they mean by formalities?
So capacity means that the person signing the document actually has the legal authority to bind their company.
Okay, that makes sense.
Like if you negotiate a massive software deal with a junior sales rep who doesn't have board approval to sign, that contract might be entirely invalid because they lacked capacity.
Oh, wow.
Yeah, you always need to verify that the signatory is authorized.
That is a crucial detail.
Yeah.
And formalities.
Formalities refers to the fact that the law requires certain types of contracts to follow specific formats to be valid.
Like having it in writing.
Exactly. For instance, in many jurisdictions, agreements regarding the sale of real estate or assigning copyright legally must be reduced to writing and physically signed. A verbal agreement or a handshake simply won't hold up.
Okay, so you've protected your internal team and you've formalized your external contractors. But the moment you start delivering to clients, you expose yourself to a completely different type of risk, right? The consumer.
Yes, absolutely.
The toolkit highlights two massive laws of general application you have to comply with to maintain market trust: the Consumer Protection Act, or CPA, and POPIA, which governs data protection.
These laws really act as the baseline for how you interact with the market. You cannot simply write your own rules and bury them in your terms and conditions.
Let's talk about the CPA first.
Yeah.
Because the sources note that it guarantees a 6-month automatic warranty of durability. So if I'm a founder selling custom-built office furniture, my terms and conditions cannot say all sales final, no returns after 30 days if the chair leg breaks under normal use in month 4.
Exactly. The CPA supersedes your terms and conditions. If your product fails within 6 months, the consumer has a statutory right to choose between a refund, a replacement, or a repair.
Wow, that's powerful.
It is. If your business operates as if that law doesn't exist, you erode market trust and invite regulatory fines.
And POPIA, the Protection of Personal Information Act, is equally critical for trust. The sources mention it revolves around 8 specific principles of data processing.
Yes. Principles like accountability, purpose specification, and maintaining security safeguards.
But let's ground this in founder reality. Say I'm setting up a simple landing page right now to collect email addresses for a newsletter.
Okay.
What specifically do I need to change on my website today to be POPIA compliant?
Practically speaking, you must clearly state exactly why you are collecting that email address. That's the purpose specification. You cannot collect emails for a newsletter and then legally sell that list to a third-party marketing firm. You also need a clear privacy policy accessible on that landing page detailing how you store those emails securely.
And what if they want off the list?
You must provide users with an easy way to opt out or request their data be deleted.
Transparency is the ultimate goal there. So we've talked about protecting the customer, but what about protecting the business, specifically from clients who simply refuse to pay their invoices?
Ah, the classic founder headache.
Right. The toolkit introduces a mechanism called an acknowledgement of debt, or AOD, specifically under Section 57 of the Magistrates Court Act.
This is one of the most powerful practical tools in the entire legal toolkit for debt collection.
The way it's described, it sounds like getting the opposing team to sign a full confession before the trial even starts.
It really is.
Usually, if a client owes you money, you have to get in this agonizingly slow line of standard litigation summons, pleadings, discovery, trials. It drains your cash flow. But an AOD changes that mechanism entirely, right?
It does. If you can get the defaulting client to sign a Section 57 acknowledgement of debt, they are formally admitting to the exact amount owed and agreeing to a specific repayment plan.
And what happens if they miss a payment on that new plan?
That's the beauty of Section 57. You skip the investigation and go straight to the sentencing, to use your analogy.
Like a legal fast pass at a theme park.
Exactly. The law allows you to take that signed AOD and fast-track it straight to a court judgment. You bypass the lengthy trial process, significantly reducing your legal costs and the time it takes to enforce collection.
That is a phenomenal strategic tool. So the final asset class the toolkit says you must aggressively protect is your intellectual property, or IP. And they break this into 3 main legal categories, right? Trademarks, patents, and copyright.
Yeah. Trademarks protect your brand identity, so your name, your logo, your slogans. Registering a trademark is what stops competitors from passing off, which is the unlawful act of tricking customer into thinking their inferior product is actually yours.
And patents.
Patents, on the other hand, protect novel inventions and industrial designs.
And finally, copyright, which protects creative works, literary, artistic, musical, or digital content. Now, the sources make a very clear distinction here.
Yeah, I do.
While trademarks and patents require formal, often expensive registration, copyright is an automatic right. It exists the moment the work is created in a tangible form.
Yes.
But here's my question. If I don't register it, how do I actually prove a digital training course or a workbook is mine if someone just rips it off and sells it on their own website?
That is the inherent challenge with automatic rights. Because there is no central registry, the burden of proof is on you. So the toolkit explicitly advises that you must mark your work to establish a paper trail.
What does marking practically involve?
It is as simple as placing the copyright symbol, the C in a circle followed by the year of creation, and your name or company name on every single piece of material you produce. That's it. While the right itself is automatic, that marking serves as a public claim of ownership. It acts as a severe deterrent to infringement and provides crucial evidence if you ever have to send a cease and desist letter.
A simple symbol does a lot of heavy lifting. And before you even get to the point of a finished product, the toolkit stresses the absolute necessity of NDAs, non-disclosure agreements.
Oh, essential.
The rule is you must get these signed before you pitch an idea, before negotiations start, and before sharing sensitive information with potential partners.
Because once confidential information is out in the public domain, you cannot unring that bell. There is no legal mechanism to make a secret again. Your competitive edge is just gone.
So what does this all mean? Let's bring this entire framework together.
Sure.
The primary objective of this Legal for Startups toolkit isn't just to make you compliant for compliance's sake. Compliance is just the baseline. The real goal is to make you, the solopreneur, highly capable. By setting up the right protective entity, formalizing your internal agreements even when it feels a bit morbid, strategically outsourcing your capacity through precise contracts, and aggressively protecting your IP, you fundamentally transform your legal paperwork.
It stops being a frustrating, confusing maze, and it becomes a strategic asset that allows you to scale your business with absolute confidence.
It gives you the scaffolding to build something massive without fear of it collapsing.
And, considering how the sources advocate for using project management tools like RCI and fishbone diagrams for your legal setup, it raises an important, slightly provocative question for you to ponder.
Oh, I like this. What is it?
If legal compliance is really just another dynamic project management process, how might applying an agile software development mindset to your legal contracts change the way you negotiate and adapt to market shifts in the future?
Oh, that's a brilliant thought to leave on. Treating your contracts not as static, dusty documents locked in a drawer somewhere, but as iterative, adaptable agreements that evolve in real time as your business pivots.
It completely changes the game.
So the foundation is poured, the structural walls are up, the legal blueprint is executed perfectly. Now it's up to you to take those keys, open that freshly painted front door, and get to work. Thanks for joining us on this deep dive.